Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate and a corporate lawyer. Today we will discuss an important topic concerning common doubt in check cases. If you want to enhance your information on the subject, I request all of you to maintain a proper notebook with pen or pencil so that whenever you are having the resembling trouble, you could easily encounter the same without any panic or worry. First of all, we will discuss the check matter. As we know that we are having section 138 of NI Act to deal with check matters. Check matters inter alia derive its authority from a process, because whenever a complaint is filed by the concerned complainant under section 138 of NI Act, he is having a story. The common story is that the concerned accused is my friend, and due to that relationship inter alia, he borrowed money from me. When the money is borrowed, he gave me a post dated check, that is called PDC, or to pay that amount he inter alia issued a check. When the check was submitted to the concerned bank, it was dishonored due to reason mentioned in the memorandum. Finally, a notice is given which is served, but despite of that, payment was not made within 15 days from service, and finally a complaint is filed within the period as required by section 142 of NI Act. Please be noted, there is a common doubt regarding the limitation. When a check is dishonored, the notice is to be given within 30 days from dishonor of check. From service of notice, the accused is required to make payment within 15 days. If the payment is not made in that scenario, in next 30 days, the complaint could be filed as per section 142 of NI Act. The second doubt is that, is it compulsory to give reply to the notice? I want to clarify that you are having a constitutional right to keep silence. The right is given to you by Honorable Supreme Court in an important judgment cited as 2008 Criminal Law Reporter Supreme Court page 102. But at the same time, we are having another judgment of Honorable Supreme Court, that is 2010 Criminal Law Reporter Supreme Court page 444. In case reply is not given, the court may draw adverse inference against you. For this, you may peruse section 114G of Indian Evidence Act or section 119G of Bharatiya Sakshya Adhiniam 2023. So, reply is required to be given. Now the important question arises, what will be the consequence if reply is not given? For which we have to study Order 8 Rule 4 of CPC. It says that if reply is not given, reply if given, if based on general facts, in that scenario the pleading of concerned petitioner or plaintiff will be deemed to be correct or genuine. So we have to raise the proper pleadings in our reply if we want to survive in the case. Otherwise, we could not be succeeded. Because the prime problem for us during the trial proceeding is section 139 of NI Act. It says that whenever a check is given and it is signed by you, the court will presume that it is given to pay a debt, either in whole or in part. To review the presumption, the burden is on you, but to discharge the same, you are not required to prove your defense beyond reasonable doubt. You can do so by doing the cross-examination or by stepping in the witness box with appropriate defense evidence. The primary defense in that scenario would be the reply to the said notice. Because if reply is given, there is no rejoinder, then you may take the benefit. But reply is to be given on the basis of theory of preponderance of the probability. That is commonly called the theory of probable defense. It is different from probable defense. The theory of probable defense comes within the preview of MBA syllabus. As you know that I am also an MBA student in addition to be a lawyer. So I study all the perspective, either concerned with legal or concerned with administrations. So to raise the same, we have to do one thing, that is called operational research. I want to clarify that the term is not common in legal science, but without doing a proper operational research, we cannot collect the raw material. And if the raw material is not available in that scenario, we cannot apply the legal principle. Because in our country, lawyer believe to fight the case. But my theory is that first we have to do the operational research, means collection of raw material, then applying the legal principle, that is called management, and after that we should have the proper strategy to proceed. If we are not going to emphasize on the same, in that scenario we are going to lose our important case. If you want to raise a proper probable defense in that scenario, you have to set up a proper defense theory looking to the facts and circumstances. For example, Mr. A is having a case against Mr. B. The case is that Mr. B borrowed rupees 10 lakh. But Mr. B in defense is having the two important documents. Number one, agreement duly executed, in which it is mentioned that only rupees 1 lakh had been borrowed. And apart from that, the amount is repaid, and Mr. B is having the bank entries. And the amount is paid prior to the check dishonour. In that scenario, he is raising a probable defense. And finally, the case would fail if Mr. A inter alia failed to give the explanation regarding the said transaction. Apart from that, I want to clarify that there is a common doubt that if we inter alia give reply to the consent notice, in that scenario our case would be affected and entire story of defense would be in the hand of prosecution prior to complaint. Please be noted, the entire case for check is based on documentary evidence. We are having multiple documentary evidence: check, memo, notice, acknowledgement, postal receipts. The documentary evidence is basically a primary evidence. It is the best piece of evidence. So in that scenario, the consent complainant cannot change the theory. If the consent complainant changes the theory in that scenario on the principle of self-inconsistent statement, we could have the benefit. For example, if Mr. A says in notice money is given as friendly loan, but after reply Mr. B in the complaint says that it is basically a business loan, it is called a self-inconsistent statement. It inter alia causes the possibility of false implication in case Mr. A failed to rule out the said changes. In that scenario, on the basis of theory of probable defense, the case would fail due to insertion of theory of self-inconsistence. So, I think that I am totally able to remove the common doubt of you concerning the check matters. So, we can conclude that whenever we are having a notice of check case, it is requested to give reply. You have to raise the proper probable defense, not probable defense. Apart from that, you have to stand your case with the proper specifications, consistencies and corroborations, so that you could win a false check case without any worry or panic. See you in the next video. Till then, Jai Hind, Jai Bharat.